Hi guys, welcome to Campus Oasis Law Tutorials. I am your instructor, Ilemobayo Aboyewa. In this video, we will learn how to draft a power of attorney in a simple and practical way. We would also talk about the different parts and clauses that make up a power of attorney. By the end of this video, you will have learned how to attempt any power of attorney drafting question that may show up in your bar final examination. So let's get started. Let me refresh our understanding on some fundamental aspect of power of attorney discussed in the main tutorial video. We define power of attorney as a transaction by which a legal or juristic person A empowers or confers on another juristic person B the legal authority to act lawfully on his behalf. We identified the person A as the donor while the person B as the donee. Now, if you look very closely at this simple definition, it reminds you the purpose, the capacity, and the scope of a power of attorney. The purpose of a power of attorney is so that the donor can empower the donee to act on his behalf, such that he that has seen the donee has seen the donor. So that makes the donee's action legally the same as that of the donors. So, for example, if a donee is appointed to sign a deed of assignment on behalf of the donor, the law will, for the purpose of that transaction, treat the donee's signature as that of the donor. However, the law provides that for a power of attorney to be valid, the party involved must be juristic persons at law. That is, they must be persons known to law, natural persons or artificial person. Like, you listening to me, you're a natural person, right? A company is an artificial person, right? So, a donor and donee must be persons at law. So that follows why I taught you that a director of a company cannot be appointed as a donee. Rather, the company is what can be appointed as a donee. Then the company would act through its directors. So you take note of that very, very important aspect of the validity of a power of attorney. And finally, a power of attorney can only be used for lawful purpose. For example, a donor cannot appoint a donee to break the law. So, like, go and slap somebody's face, right? That's for an unlawful purpose. Take note that the transaction is a power of attorney, right? The legal instrument of delegation is also known as power of attorney. So you don't have to cram it. Transaction is power of attorney. The legal document is also power of attorney. So moving on, what are the modes of creating a power of attorney? A power of attorney transaction may be created in two ways. That is, that document may be drafted in two ways. It could be made in mere writing or by way of deed, right? When it's in mere writing, it's just a simple written document, right? Not necessarily following a format. But the moment it is a deed, it is a more formal legal instrument with a defined structure of what must be contained in that document. And what determines whether a power of attorney will be made in mere writing or by deed is that specific act, is a specific act that the donor wants the donee to carry out on his behalf. So remember that if the law requires that an action be done by deed, then the power of attorney authorizing the donee to carry out that act must also be created by deed. Also, note that when a power of attorney has been created by deed, it also goes to the root of how that power of attorney can be expressly revoked. So, a power of attorney made by deed cannot be revoked in mere writing. You have to use something higher, right, to revoke that. So, but a power of attorney made in mere writing can be revoked in mere writing or by way of deed. But a power of attorney made by deed can only be revoked by way of deed. And of course, you simply prepare a deed of revocation to revoke that specific power or the entire power of attorney granted to the donee. So now that we have refreshed our memories on the meaning, the purpose, the mode of creating a power of attorney, how do you attend to a client who has approached you to prepare a power of attorney on his behalf? What are the information you need to elicit from him so that you as a solicitor can prepare a good and well drafted power of attorney that becomes valid and enforceable in law? Now let's look at some of this information you need to extract from your client. First, you want to ask from your client the particulars of the donor, right? Maybe your client is that donor. So you need these particulars, and by these particulars, we are referring to his name, his address, his occupation, and signature. And also, you need the particulars of the donee because that's the purpose of the power of attorney. Is so that the donor can appoint a donee. So who is the donee? So if he now tells you, I want to appoint the director of a company, or there's one chairman I like him, you're like, that's not going to be valid in law. You now start explaining that is it that director has a company and we appoint that company, but the company will act through that director. So you're able to advise him because the moment he mentions a particular of his donee, you can say no, this person is not a person known to law, right? So you want to get the name, the address, the occupation, and signature, and of course you also want to get the particulars of the attesting witness and also the particular property that is involved. You know that in this syllabus, I already told you that the focus is mainly on land transactions. So power of attorney is not being used to say, okay, go and withdraw, go and take a loan, go and no. Mainly the focus is on land transaction, like we mentioned in module 1 of our tutorial class. So you want to know the particulars of the property involved, right? And as we will see when we start discussing the clauses, you cannot just just write things in a generic way. Don't just say, just go and manage the blue house. Blue house where, right? Blue house can be blue house anywhere, right? So you want to be specific about the location, the description of that property so that the donee knows what exactly the particular property that the donor has empowered him to act on his behalf. Also, you want to know about the nature of the powers to be donated to the donee by the donor. That is, what do you want the donee to do? So you have approached me that you need a power of attorney. The question is for what? Why? Okay, what do you want him to do? You want the donee to be able to sell your property. You want the donee to be able to manage your property. Do you want the donee to be able to institute legal actions against tenants if they don't pay? Do you want him to collect rents on your behalf? Those are the questions that comes under the nature of the powers to be donated to the donee. And also you want to find out whether or not the power of attorney is to be made irrevocable. You want to find out, why are you creating this power of attorney? Is it that you owe the donee and then because he has an interest, you want to make it irrevocable, coupled with an interest, right? And so he would answer you that, okay, no, I don't want it to be irrevocable. I want to be able to, by conduct, right, without any mutual discussion again, revoke it. Then you're able to know how to go about drafting that particular power of attorney, right? You can also advise him that, okay, you know what, we can even make it, irrevocable for a period of no less than 12 months so that if anything happens to you, you can cure the defect, right? The implication of law will not set in. You may also want to ask him the duration of the exercise of the power of attorney. For how long is this power of attorney? Fine, you have said that you don't want to make it irrevocable, right? But for how long do you want this power to last? So that is that flexibility that comes with when you are attending to your client as to drafting a power of attorney. So when a client approach you to draft a power of attorney, it's not for you to just jump at it and start drafting. You ask the necessary questions so that you can know what exactly you want to draft. When the client mentions an act that needs to be done by deed, then you know that, okay, this power of attorney needs to be by way of deed. But if he mentions something that is just, that the law, for example, collecting rent does not, it does that's not a power that needs an act to be by deed. So you can know, you can prepare that in mere writing. So you take note of all this very important information, and I'm sure that if it comes out in your bar final examination, these are work over areas, chip mark areas that I trust that you will attempt excellently well. So now let's discuss the power of attorney made by deed, which will be analyzing the parts and the clauses. So what I will do is to take time to explain each of these parts and the clauses, then show you how to draft the clauses for a power of attorney. So ensure that you don't skip the video so that you don't have questions that I have already answered during the course of explaining this topic. So what are the parts of a power of attorney made by deed? So you have been confronted with a question in your bar finance examination asking you to list the parts of a power of attorney, right, made by way of deed. Then you go ahead. You remember what we learned under our topic on deed, right? Every deed is divided into 4 parts, right? And that is the same for any type of deed. You have the introductory part, operative part, miscellaneous part, and the concluding part. Let's go again. Introductory part, operative part, miscellaneous part, concluding part. Let's go again so that you remember. Introductory part, operative part. Yes, what's the next one? You got it. The last one, concluding part. What about if you are asked to list the clauses in a power of attorney? That is, you were not asked to talk about the parts of a power of attorney. You were asked to list the clauses in a power of attorney. What are the clauses in a power of attorney? You have the commencement clause, date, reciters, appointment clause, power clause, omnibus clause, irrevocability clause, the testimonium, the execution clause, the attestation, and franking. Now you may be wondering why some of, at least the reciter is in red, why the irrevocability clause is in red. As we proceed in this lecture video, you will understand why I've put these two, clauses in red, because it is not compulsory that it must be in a power of attorney. However, please listen. If what you were asked in the question is to list the clauses, then you include everything. You include both the reciter, you include the irrevocability clause. So, what if the question is not just the generic, tell me the parts of a power of attorney or list the clauses? It's now very specific. Tell me, list the introductory part of a power of attorney. Then it's not asking you for everything. It wants you to be specific about the introductory part of a power of attorney. So that is what we're going to do now in the next subsequent slides. So we're going to divide those clauses and fix them permanently into their different parts. Remember the illustration I gave you. The same way you have your head. Your head now has what? Your eyes. So your eyes is the clause. Your head is the part, right? Your eyes, your nose, right? Form the clauses that is part of your head for illustration purpose. So if you are asked for the introductory part of a power of attorney, you have the commencement clause, you have the date, and you have the recitals. So the introductory part of a power of attorney includes what? Commencement, date, yes, recitals. I always ask us to go back again. Commencement clause, the date, and recitals. What about the operative part of a power of attorney? For the operative part, you have the appointment clause, you have the power clause, you have the omnibus clause. So take note of that. Of course, I don't expect you to be surprised. I already told you that the parts of every deed, they are the same, but the clauses differ based on the particular type of deed involved, right? So the operative part of a power of attorney, you have the appointment clause, you have the power clause, you have the omnibus clause. For the miscellaneous part, you have the irrevocability clause. This is the aspect where you put the irrevocability clause. And for the concluding part, of course, you already know it. Maybe we should even skip it, right? Let's go together. We have the testimonium, execution clause, attestation clause, and franking. You have the testimonium, you have the execution clause, you have the attestation clause, and you have the franking. So what we're going to start doing now is to discuss each of these clauses, tell you the function or the reason why they have been included in the power of attorney. Then we have the sample draft, which you would be able to use if you are asked any question in relation to that particular clause. Say, for example, you are told to draft the commencement clause of a power of attorney. You know how to draft it. If you are asked for the function of the commencement clause, you also be able to answer that question. So that is what we're going to look at in the next video.